Let's see, give me just a second here.
I explained to
Sure.
my client's family why it's always appropriate to be here exactly on time, since something may go off or not.
Right. And especially when you're coming from East Tennessee.
Correct, Your Honor.
Thank you for being here.
Thank you. May it please the court, good afternoon. Ann Short, representing Ashley Kroese in this appeal. I'd like to reserve 3 minutes for rebuttal, please.
Yes, ma'am.
July 18, 2020, Franklin Road, Williamson County, approximately 4:56 a.m. We have a two-car head-on collision. Both occupants of the vehicles are taken to the hospital. One of the occupants dies, is pronounced dead at Vanderbilt. Ms. Kroese survived the collision and was charged with multiple vehicular homicide-related offenses, for which she was tried before a jury and was convicted in this case. One of the issues I'll get to a little bit later has to deal with the especially mitigated sentencing issue in this case, but let me start with the search warrant affidavit and the probable cause for the issuance of that. The affidavit is very bare bones. What the state relies on, and the trial court in its own way of saying this was not a mere accident, focused on the time of the accident at 4:56, the driving in the wrong lane of traffic for some distance, and I say that because the affidavit is incorrect when it cites it was for a mile or more. The parties later stipulated, the state did, that is absolutely incorrect. It was 3/10 of a mile. The trial court also, however, made it clear later on that regardless of 3/10 of a mile or 1 mile, in the court's opinion, that contributed to probable cause for a search warrant to do a blood draw in this case, and the headlights not being activated. Nothing in the affidavit dealing with speed in this case.
Why is that not enough? The headlights not being activated, or 0.3 miles or 1 mile? What difference does it make?
When we canvass the case law in this state, Your Honor, this fact pattern is elusive. Let me put it this way. All of us have done a bunch of research to see if we can isolate a situation where we're dealing with facts that have no other indicia of intoxication. There are 2 cases in Tennessee probably that set the floor that you really can't go below. One is the Bell case, where you had the gentleman who evidently performed satisfactorily on the field sobriety test, but the court said that's one circumstance, and then looked to the fact that there was the odor of alcohol and the gentleman admitted he had been imbibing too much. Again, indicia of intoxication. There is nothing, not only is it not in the affidavit, Your Honor, it's not in the trial record. There was no smell whatsoever about Ms. Kroese at the scene of the accident. There were no alcoholic beverages, cups, bottles, whatever, in or near her vehicle. There was no admission of drinking. There was no impairment beyond, obviously, she was physically injured severely. And when she got to the hospital, Vanderbilt did not, based upon its evaluation, request that a toxicology screen be done on her. So when we look at the case law, and as I said, the Bell case, and possibly even the the Betts case may be as low as you really can go. In that case, we're left with the probable cause being based upon, the officer thought the accident was the defendant's fault, and he smelled of alcohol. There's always this other physical type of indicia or an admission of drinking when you look at the cases that support a finding of probable cause, because we're talking about seizing the blood. So the probable cause related to the intoxication is clearly at issue in this case, not just probable cause that a crime has been committed. For example, the moving violations that were involved with the accident. We're dealing directly with probable cause as it relates to intoxication to be able to support the search warrant.
And that, the warrant says your client, the officer, learned that the defendant drove on the opposite lane of travel for more than 1 mile, observed by traffic cameras prior to the crash at the intersection of Franklin Road and Concord Road without headlights, looks like it's been written, or head beams perhaps, activated in a black Jeep. That's not probable cause?
No, Your Honor, not pursuant to the case law. And as I said, we did some extensive research. We found the one case out of Michigan that is unreported, where the affidavit cited reckless driving on the motorcycle and speeding, and the court said that's evidence of something, but it's lacking the evidence of intoxication being involved, and what you're wanting is a search warrant to go do a blood draw in the case. We also found recently, and I know we filed a motion rather late with our reply brief. Actually, we were granted until the 16th of this month to do the reply brief, but I wanted to hope the court would like to read it before argument, so we went ahead and did that. We also found that there is now appears to be a difference of opinion within Tennessee between Hamilton County.
A trial judge in Hamilton County. You're not talking about an appellate court, correct?
I am not, Your Honor, and pursuant to what the Tennessee Supreme Court has said in Lawson and reading the take judicial notice, I understand. We certainly talk about this court can take judicial notice of its own records in this case. The only thing I can suggest, and I wasn't offering it as persuasive, but because of the tension in this, there is one possibility, depending upon how the court otherwise views the facts in the affidavit stating probable cause. This court could issue a very limited remand to the trial court with directions to very quickly convene a hearing to let the defense present this case to the trial court, have argument on it, let the trial court see if it would change its mind based upon what the Hamilton County judge did, and then immediately appeal that back up to become once again part of the full case. Otherwise, Your Honor, honestly, I expect you to say we're not going to take judicial notice of it. I'm just trying to offer a no but option to the court with this. But I think the court will find from its own research, they're just, this fact pattern, it just doesn't really exist unless there's something else you can tie into it with the four corners of the affidavit, which is all we have to go by. Nothing. No smells, no statements, no behavior, no witnesses we respectfully submit that it does fail to state probable cause and that search warrant should not have been issued. The other issue that we want the court to take particular attention of is the especially mitigated offender statute. I enjoy sentencing appeals. I've been doing them for a long time. I've never done an especially mitigated sentencing case before, and honestly was surprised when I looked at the case law, and it's just kind of a confusing array of what do you do with this. The trial judge started the sentencing hearing in this case by saying that I'm inclined to grant it especially mitigated sentencing. By the end of it, however, the judge denied that sentencing. We have clear frameworks, and this court really has been the one that has plowed that ground. For example, probation, judicial diversion. What are the criteria the trial judges should look at in making those determinations? There just isn't anything here. You see vague statements, well, it's a discretionary matter. But look at the Sentencing Commission comments to 109. They say it's discretionary, but in the very next sentence, they say the discretion is controlled by subsection A, which is no enhancement factors, and mitigating factors.
Wait, you know this court reviews sentencing decisions under an abuse of discretion. I'm not clear, are you asking us to adopt some kind of new standard with regard to especially mitigated offenders?
I don't think this is an appellate abuse of discretion issue, Your Honor. What the problem is, for example, like with probation, and we know how appellate review has to be done pursuant to bias in the other cases, but the Supreme Court has made clear the underlying framework of what the trial court has to do and look at. That's not a bias issue. That's not an appellate review of that. This is the framework that stays put. What this case demonstrates is a need for this court to articulate a clear framework for determining if a defendant is an especially mitigated offender, and then what to do with that. The Sentencing Commission comments indicates that the discretion that speaks of really is just the no enhancement mitigating factors. You read the sentencing hearing transcript, and the court, you could tell, was very sympathetic. The young lady, absolutely remorseful. Over 90 community letters written. No criminal history whatsoever in this case. This wasn't close as to whether there was anything not mitigating or anything enhancement in this particular case. What we believe is that the record is adequate, more than adequate, for this court to impose especially mitigated sentencing in this case. Judge Holloway, were you wanting to ask a question?
I was, and I'm sure, and I apologize for my voice, but, the Supreme Court's made it clear that enhancing and mitigating factors are advisory only. How would we take enhancing and mitigating factors in this case and say, even though they were advisory only, you should do it this way once the Supreme Court has already ruled differently?
Your Honor, I think the whole framework of 109 is treating this in a different fashion. It's one thing to say there are or not enhancement and are or not mitigating, and how are we going to weigh those, for example, to come up with the length of a sentence. That's not specifically what 109 is talking to. That section is talking about eligibility to be sentenced as an especially mitigated offender. And I'm sorry.
So it's separate, and your argument is that statute on especially mitigated offender has some sort of different standard for the trial court than, say, 108, which is determining a career offender or standard offender or multiple offender? That's somehow it's a different standard for the sentencing court?
Within, yes, Your Honor, I mean, within 109,
It's not just advisory? As Judge Holloway was saying, these enhancing and mitigating factors apparently are advisory.
I'm not avoiding your question. Let me see if I can
Well,
answer it this way.
I may not be saying it.
When we're talking about standard range 1, range 2, and range 3, we're not talking about advisory situations. We're talking about counting convictions for the most part. This is a category
Okay, I
that the
understand.
legislature has separately created and has indicated what the qualifying criteria is, which is no prior felony convictions and mitigating but no enhancement factors. That's not a weighing proposition, Your Honor. That's not what it's talking about. It's just a flat out mitigating, no enhancement, no prior felony convictions.
But the statute doesn't say shall. It says that if those certain criteria are met, then the court may sentence the person as an especially mitigated offender, which again is discretionary.
It is until, Your Honor, you look at the Sentencing Commission comments. And we know that the Supreme Court...
I'm just looking at the statute and the plain language of the statute.
But the Sentencing Commission comments, the Tennessee Supreme Court has said, indicates legislative intent on the matter. The case law, and we have cited that in our brief. And when you look at the very next sentence, it describes that as being the criteria for that discretion. Maybe it's inartful, but the Sentencing Commission is subsection A, B, 1 and 2.
Well, I mean, the legislature tells us what the law is, and that statute just says, if those criteria are met, then a judge in its discretion, a trial court may sentence as an especially mitigating offender. I mean, I see your argument, but the statute's clear to me. I'm going to take a lot of convincing otherwise that it's not clear that it's discretionary.
I would like to spend my 3 minutes in rebuttal, seeing perhaps if I can persuade Your Honor.
Thank you.
Yeah.
General Wilbur? Wilbur.
Yeah.
Wilbur, sorry.
I hear that
Jenna.
a lot. Good afternoon. May it please the court, Lacey Wilbur on behalf of the state. Your Honors, the defendant has argued here today issues 1 and 4, so I will only respond to those issues unless this court has questions on issues 2 and 3. With respect to issue 1, the affidavit for the search warrant absolutely provided probable cause that the defendant was driving while intoxicated. As Your Honor noted, there are 4 facts. I think I said it was 3 in my brief, but I broke it down into 4. So we have the time of the crash, 4:56 a.m. She drove for more than a mile, as what their understanding was at the time this affidavit was issued, drove more than a mile in the wrong lane on a 5-lane highway. The 5-lane highway is not in the affidavit, but it's driving on the wrong side of the road for more than 1 mile. She had no headlights activated. That's the 3rd fact. And the 4th one is she hit this officer head on. So these 4 facts definitely combine to give probable cause in this affidavit. And she's relying on other cases and other case law, but we're within the confines of the 4 corners of this affidavit. And this affidavit definitely provides probable cause that she was driving while intoxicated. If Your Honors have no further questions on that issue, I'll address the sentencing issue, which honestly I didn't understand that she was maybe making a challenge to buys, but buys definitely applies even to this statute. And as Your Honor, I was going to point out, the statute says a trial court may sentence a defendant as an especially mitigated offender. It does not state shall, and we're not in the advisory commission comments. We're up in the body of the statute, which is the legislature's intent, and they said may. And the trial court, I think it actually helps the state's argument where the court at the beginning said, I'm inclined to maybe sentence her as an especially mitigated offender. But then after hearing all of the argument, all of the proof, the court said, I think that sentencing her as such would send a wrong message to the community and a wrong message to the victim's family, so I will not sentence her as such, and I will sentence her as a range 1 standard offender. And that is totally within the discretion of the trial court. The trial court listened to all of the defendant's evidence, the mitigating evidence, received the 90 letters in support of the defendant, heard victim impact statements. The trial court considered everything and decided to sentence her as a range 1 standard offender, and the trial court properly sentenced her. If this court has no further questions, we ask that you affirm the judgment of the trial court. Thank you.
Thank you, General. Okay, Ms. Short, you've got your 3 minutes. That is what you asked for, isn't it? 3 minutes?
Yes, it is, Your Honor.
You have your 3 minutes.
We're not making a bias challenge at all. As I said, what I am extending to the court, as this court has done, for example, in the Bingham case in dealing with probation, in this court dealing with what are the appropriate considerations for judicial diversion once you get qualified initially, what guides the court's discretion. If you are inclined to ignore the Sentencing Commission comments, which I ask you not to, but if you are, what I'm saying is this case, because of the fact pattern, cries out for this court to say, what should guide your discretion in this case? An especially mitigated offender, it's not a mercy classification. In our reply brief, we pointed out the Sentencing Commission has done extensive recidivism research and has concluded that in terms of zero conviction offenders and even 1 conviction offenders, there is an enormous difference in their recidivism rates. There is a good policy reason for having this and for using it. But if the judges don't know how or when, saying you have discretion with no standards to guide it, discretionless. I mean, that's why I say I invite this court. This is a perfect record. If you're going to go that way with saying, not looking at the comments, then give us something to guide the court's discretion. We believe this was a perfect case for Ms. Kroese to have been sentenced as an especially mitigated offender, and for the 2 to have been applied, both the 10% and the 20% reduction to the red day. Keep in mind, there was no alternative to incarceration in this case. Probation was ruled out. Judicial diversion you couldn't do. Community supervision. Under the statute, no good time credit she earns can be applied to her red date. It can only be toward the expiration. Those are valid considerations, among others, we believe, in dealing with an especially mitigated offender. Thank you, Your Honors. I appreciate your time, attention, and as a point, just one point of privilege, since I'm practiced mostly in Knoxville, the clerk's office had to deal with me frequently, and being somewhat of a dinosaur, I still send in paper briefs and I fax my motions, and the clerk's office was so professional and so helpful, and I just wanted them to hear that in front of Your Honors as to how much I appreciated it and how good they really do their job.
They are top-notch.
Yes.
In all three sections, actually, so we appreciate their work.
Thank you, Your Honor.
Thank you both for your arguments. Anything else, Madam Clerk?
No, Your Honor.
Okay, we will be in recess until the second day of this docket, 9:30 tomorrow morning.
All rise.